Companies Act, Section 413, Term of Office of the President, Chairperson, and members of NCLT and NCLAT. Section 413 of the Companies Act, 2013 lays down detailed rules regarding how long the President and members of the National Company Law Tribunal, NCLT, and the National Company Law Appellate Tribunal, NCLAT, can hold office. This provision ensures consistency, fairness, and accountability in the functioning of these bodies, which play a major role in resolving corporate disputes in India. This section clearly defines their tenure, retirement age, reappointment conditions, and certain safeguards for government officers serving as members. 1. Tenure and reappointment. According to the law, the President of the NCLT and every other member appointed to the tribunal shall hold office for a period of 5 years from the date they assume charge. After the completion of this term, they are eligible for reappointment for one additional term of 5 years. This means that the maximum overall tenure they may serve is 10 years, subject to reappointment being approved. 2. Retirement age limits. For members of the NCLT, the law also specifies upper age restrictions. The President of the Tribunal is permitted to continue in office until he or she attains the age of 67 years. All other members of the NCLT must retire upon reaching the age of 65 years, even if their 5-year tenure has not yet expired at that point. There is also an important eligibility condition. A person must have completed at least 50 years of age to be considered for appointment as a member of the NCLT. This requirement ensures that only those with sufficient maturity and professional experience are appointed. Another safeguard included in this section states that a member who comes from a government department or service may retain a lien on their previous post in the parent ministry, department, or cadre. This lien may be retained for a maximum period of 1 year, providing employment security and a fallback option while transitioning to tribunal service. 3. Tenure and reappointment. Similarly, the chairperson of the NCLAT and every other member appointed to the appellate tribunal shall hold office for a 5-year term, commencing from the date they assume office. They are also eligible to be reappointed for one further term of 5 years. The reappointment provision ensures continuity of judicial leadership when needed. 4. Retirement age limits. The law prescribes a different, slightly higher age limit for the appellate tribunal due to the seniority required in appellate roles. The chairperson of the NCLAT can remain in office until the age of 70 years, which reflects the requirement that the chairperson must be of extremely high judicial standing, such as a former Chief Justice of a High Court or a Judge of the Supreme Court. Other members of the NCLAT must retire upon reaching the age of 67 years. As with the NCLT, individuals must have completed 50 years of age before they can be appointed as a member of NCLAT. The provision allowing members to retain lien over their former government position is similarly applicable, and again only for a period of up to 1 year. Importance of Section 413. Continuity yet limited tenure, preventing indefinite appointments. Experienced leadership, through minimum age and professional requirements. Clear retirement age, avoiding uncertainty in judicial positions. Administrative stability, by protecting career rights of government-appointed members. Professional accountability, since reappointment depends on performance. By clearly defining how long members and leaders of NCLT and NCLAT may serve, Section 413 supports the smooth and transparent functioning of India's company law adjudication system and reinforces public confidence in its institutional framework. For more details, contact us.